Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Judge Milkey. With me on the panel today are my colleagues, Judge Blake and Judge Henry, and we will be hearing the 5 cases on the list today. The final case, the 6th case, has been submitted on briefs. I know the 2 counsel who are coming before us now are old hands at this, so I don't need to go over the ground rules, which are the same as an ordinary argument. I would remind counsel that we have read the briefs and the record, so we encourage you to jump right into your main points. And with that, I will call the first case. It's Commonwealth v. DASILVA, 2019 P 571, and we'll begin with Mr. Driscoll.
Good morning, and may it please the court. William Driscoll for Fernando da Silva. The crux of this case is shown in the jury question. The jury asked whether the mother's testimony that Mr. da Silva had confessed to her that he abused his daughter was substantive evidence that could be used against him.
Can I just interrupt you for a second? In your reply brief, are you waiving the issue with respect to the other 2 witnesses?
Yes, we are.
Okay, so this is solely about the mom's testimony?
Yes.
Okay.
The children's issue only comes in as far as the issue being cumulative and only being cured as to the 2 children, where the judge specifically did not mention the mother as also being a victim of Durgo error. So the jury, if the jury believed the mother and found her credible, then they would have believed that Mr. da Silva had confessed to abusing his daughter. That would lead to the outcome at trial. All the charges where a guilt was found were against the daughter, and none were found against the son. And that would corroborate the fact that they believed the mother's testimony and that he had confessed. However, the mother's claim was uncorroborated in and of itself. So the mother's credibility was key to this outcome. And that's where the Durgo error comes in. The prosecutor enhanced the mother's credibility by stating that she had come all the way from Brazil to testify. And as in Durgo and also Ramos, the Commonwealth cannot comment on a witness's testimony based on the burden that it imposed upon them. Here, that's exactly what the prosecutor did.
Counsel, the Commonwealth argues that you did not make this objection, the Durgo objection, as to the mother. And you say you have preserved the issue because defense counsel submitted the written instruction. Okay. Yes. So where the original objection was limited to the children, why was the proposed written instruction sufficient to alert the judge that there was an issue with respect to the mother?
The children's issue was rather rushed at trial. That obviously the complaining witnesses and Durgo error has been the case all along, Durgo and other cases, where the complaining witness was the testimony that was enhanced. In this case, the judge said, okay, we'll come back, I'll give my instruction, and I'll hear you at the midpoint of my charge if you have any questions. So defense counsel said, I'm not going to agree to your instruction without having a clue of what it is. So when he finally heard it and heard that it only applied to the 2 complaining witnesses, he wrote the written instruction as directed, provided it at the midpoint of instruction, and asked that it apply to all witnesses, not just the two children. And
Why wouldn't the jury have understood the principle as applying to all the witnesses?
because the judge in his limiting instruction actually drew out the two children and said the daughter and the son's testimony is not enhanced by their appearance at court. It didn't talk to any other witnesses, and there were only two other witnesses, both prosecution, the key being the mother, and the key piece of evidence she provided was a purported confession from the father that he had abused the daughter. The other witness was a police witness. So a reasonable juror would believe that the Durgo error only applied to the two complaining witnesses and not other types of witnesses.
Now, part of the theory behind Durgo is that you can subpoena witnesses in. So the mere fact they show up in court doesn't prove anything. If the mother is in Brazil, she can't be subpoenaed in. So doesn't that undercut the theory of the application of Durgo to her?
No, because as Ramos informs us, that you can't use a burden upon a witness for having come to testify as a reason to enhance their credibility. And here, what the prosecutor said was she came all the way from Brazil just to testify before you and to provide evidence to you. In other words, she came all the way here to provide credible evidence, and you should believe her because the burden that it placed upon her to be before you.
So the Commonwealth's response to that is that the prosecutor was just meeting a defense argument that she wasn't available to the children and that the prosecutor was just marshaling that evidence. And so we have to keep it in that context. What do you say to that?
That is a valid argument as far as opposing the defense closing. However, it's going too far to breach Durgo and to say that witnesses appeared and therefore should have higher credibility standards. It would be very similar to have the prosecutor said, and you notice that the defendant didn't take the stand in his own defense to challenge any of this evidence. That too would be error. And
Well,
that too
I'm having some trouble with that, right? Because in the defendant's closing argument, there was a lot, I think Commonwealth says half of the argument was devoted to the mother's credibility. And the argument was that the mom had no idea what was going on in the kids' lives, and she had up and left to Brazil, which is part of the reason the defendant said the daughter made up the allegation in order to get her mom's attention. So I agree with you in a broad sense. Someone coming from Brazil to testify, there may be an issue, but tied and anchored to these facts, and especially what the defense argued in closing, I'm struggling with your argument. The defendant made her long periods of time to Brazil part and parcel of the theory of their case as it related to the daughter's allegations. So I think it's more connected than just throwing it out there that someone, hey, they came from another state, another country to come in and testify.
Well, there was significant testimony that the Brazil travel was for business, and it was more recently an issue. It was not an issue when the daughter confessed or gave her allegation to the first complaint witness, the mother, and the same with the brother. So it was not an issue that she was trying to say, you're always away in Brazil, and that's why I am telling you this, because she was not always away in Brazil at that time.
But at the transcript 4, around page 20 or so, the defendant speculates that Maria could have come back earlier to be with her daughter and chose not to because she didn't care about her daughter.
Yes, that has to do with trial. And leading up to trial, Here you have this, her daughter is about to testify about an incident which, if it occurred, is horrendous. And where is her mother to give her support? She was in Brazil on business. It was not saying that she abandoned her children. She was on business in Brazil. And one could say that, yes, she was in Brazil and she came back. What difference does that make? Except to say it was a burden upon her, and she went out of her way to be here to tell you her story. Therefore, she should be believed. Why else would she undergo that burden?
Yeah, but isn't there a suggestion in defendant's argument at trial that the mother herself didn't believe the kids because she'd be there more? And so why isn't this a fair response to that?
It's a fair response to say that the mother cared about her children and that she was available to them, that when she went on business trips to Brazil, she saw that they were taken care of. But it was not a fair response to say she came back from Brazil just to tell her story to the jury. The issue is the burden that's shown to the jury. Why else would someone fly all that distance just to be here? And the issue came up out of the jury's hearing, I believe, that the mother was supposed to be back a day earlier to testify, and her testimony was delayed because she didn't make it. She took a flight the next day. There was also an issue about whether the Commonwealth provided her transportation to the airport and all the rest of this, but that was on the side. The issue here was not that she was in Brazil. The prosecutor admitted that she saw nothing wrong with what she had said. And the judge corrected her and say, no, that is Durgo error. You're not supposed to do that. And he corrected her as to only the two complaining witnesses. So the prosecutor didn't know it was Durgo error.
And so therefore, the not guilties we shouldn't consider as it relates to mother because the judge only instructed as to the children?
Yes. So the jury were not informed that it applied to all witnesses, not just complaining witnesses. And credibility is key in sex abuse cases.
So counsel though, but on page 67 of the fourth day of trial, the judge does talk about the children. There's a whole paragraph, and again, it's page 67, lines 10 through 18 are all about the children. But then the judge says, so the fact that a witness testifies in court is not direct proof that in fact the crime about which they may testify actually occurred, or about which they testify actually occurred. So there, the judge broadened it out to witness. So why is that not sufficient?
Because the judge had already constrained it to the two complaining witnesses, then said a witness who is providing information about a crime that has occurred basically to them is the distinction. It was not that this is a error. No witness can be brought into, can be enhanced just for their appearance or their burden that they have undergone to appear before you to tell their story.
Can I just ask you briefly on the instruction question? And I know your sister agrees, at least as to the wrong crime being instructed. What is the remedy in your view for that? Is it a new trial or is it a defendant verdict?
I would love to say a defendant verdict, but it would be a new trial.
Hey, counsel, I have to ask, how did this happen?
Oh, I'm so glad you asked that, Judge Milkey.
Yeah, I can, frankly, I can understand the judges getting confused given that there were originally 27 counts, but how did both counsel miss this?
It is a good question. Mr. Da Silva could have been charged with either crime. There was evidence supporting either crime. So I think it flew under the radar because there was dissemination of pornography to a minor, but it was supported by the evidence, but if he was not indicted for the crime, he cannot be found guilty for that crime.
I think we can all agree on that.
Yeah, that's the issue. And failing to see the difference between the indicted crime was to prevent the victimization of minors. And the charged crime had to do with providing pornography to minors, a First Amendment issue, but it's curtailed to under 18, so it's constitutional. And with that, I would ask that the verdicts be reversed and case remanded for a new trial.
Thank you very much, counsel. We will hear from the Commonwealth. Feel free to mute yourself now in case there are any stray sounds.
Good morning.
Go ahead.
Good morning. May it please the court, Bridget Norton Middleton for the Commonwealth. I'd like to start with the defendant's objections to the prosecutor's closing. The defendant did not object, as the court has noted, to the prosecutor's comments about the mother. During the bench conference with the court, right after the objection, the defense counsel never mentions the mother. He focuses on the children. So the reason why Judge Locke starts his curative by mentioning the two children is because that's who the defense counsel objected to. He never mentions the mother. After the curative, which was broad, as Justice Henry, I think, noted, the judge did broaden it to witnesses. So he mentions the children, but then he recites the law. He mentions, what the limitations are when you're judging the credibility of a witness. After the curative, the defense counsel objects again to the curative, but again, he never mentions the mother. His objection is not that Judge Locke did not include the mother. His objection is that Judge Locke didn't call out the prosecutor. Defense counsel wanted Judge Locke to say the prosecutor made the mistake. And Judge Locke said, I'm not going to do that. I'm going to give the law, I don't do that. And, just in fairness, there was an objection during defense counsel's closing where he argued some evidence that argued to the jury about the victim's hymen when there was absolutely no evidence of that. Judge Locke called him up to sidebar and gave him an opportunity to fix his own error, because he said, I'm either going to tell the jury that there's no evidence of that, or I will allow you to do it to lessen the sting. So this is how Judge Locke handles his courtroom. So, and then we get to the defendant's proposed curative, and you look at the language of the curative instruction, it doesn't mention the mother. It mentions the prosecutor. That's what the defendant didn't like. He wanted the judge to say the prosecutor did this. So I think that the error below is not preserved. There's a reason why Judge Locke focused the instructions the way he did, but then he broadened them, which I think would cover the mother even under a substantial risk analysis. In terms of—
So counsel, defense counsels argued that the prosecutor may not have realized there was a potential Durgo issue here, which of course would be a concern for us. 50 years ago, Chief Justice Hennessy of the SJC said we see too many arguments challenging prosecutors' comments. And here we have the Massachusetts Guide to Evidence has a beautiful and incredibly succinct summary of what prosecutors can and cannot do. And yet almost every single day that we have argument, we get this. Now, sometimes they're meritless. I do understand that. But do you think that the prosecutor did not seem to understand there was a possible Durgo issue here?
No, I don't think that's the case at all. I think that there was a conversation at sidebar. I think that Judge Locke qualified this and said, I'm not sure I see quite the issue here, but let me think about it. I'll go back and read Durgo, but I'm going to give the curative anyway. So Judge Locke gave the curative before he even went back and read Durgo, and the prosecutor wanted an opportunity to say, Judge, there's an ability to rebut. And she clearly understood the case law and they had a conversation about it. So I don't agree with my brother that Judge Locke found this was error. I think he was trying to think quickly about what happened. I mean, you can see the transcript for yourself. There was some conversation, but he pulled back a little bit on that, but still gave the curative. The prosecutor, after he gave the curative, wanted to explain to the judge, I understand the law and this is what I was doing. And Judge Locke kind of said, we're done, you know.
So there is still a tension between the prosecutor's ability to respond to the fabrication claim and the holding of Durgo, right? I think it's a really fine line here. Do you say that it was not error because it was a fair response to the closing, and even if it was error, there's no substantial risk? Is that essentially your argument?
Yes, yes. And I would point out, this was a long closing, 29 pages. Methodically went through the evidence. There was a lot of evidence here. This was a difficult case. Defense counsel, the theory of his case, as we've said, is, you know, the mother neglected her children, which triggered their false allegations against the father. Really went at the mother about her travel. He's the first one who raised her travel and also raised why wasn't the mother here earlier. He asked her about her on cross-examination. When did you fly in? What time did you get here? And argued to the jury that a woman who had testified that she was in Brazil prior to trial because she had breast cancer and had to have a mastectomy and could only afford it in Brazil. Defense counsel argued to the jury that the most galling example of this type of behavior, meaning the mother's neglect of her children, is what happened at trial itself. Her original plan was to arrive in the US from Brazil so she could be in attendance on Monday morning. And it seemed clear if she was going to arrive Monday morning, she was going to arrive Sunday. And now that was delayed due to a hurricane. And that's certainly out of control. But what was in her control was making her plans in general. Why not come the week before? I mean, you really laid into this mother in terms of she doesn't either care about her children or doesn't believe her children because she's not at court. When you place what the prosecutor said in the context of the entire trial, the cross-examination, this type of argument by defense counsel, I think it's a fair rebuttal. She didn't go on and on for pages about it. You know, she said she's here to testify. And I've laid out my brief, page 26 of my brief. I tried to lay out a lot of the prosecutor's closing and underline what defense counsel was objecting to. And I would point out that this defense counsel jumped right up and objected about the children. He was concerned about that issue. He didn't say a word about the mother. And I would say that that's some indication that her argument, he recognized, having what he had argued to the jury about the mother, that this was fair rebuttal. So I'd ask the court to consider that in assessing, you know, whether there's any error here. Defense counsel didn't think there was an error in what she said about the mom.
And sometimes in these cases, the argument is that there were some not guilties, and obviously the closing wasn't as bad as the defendant would have you believe. But what, if anything, can we infer from the not guilties as it relates to the son vis-a-vis the mother's testimony?
That was puzzling. I don't want to disagree with the jury, but I read a lot of these transcripts. I think the victim was particularly credible in this case. I think Judge Locke, who's an experienced trial judge. Yes. Judge Locke at the end of the case took some time to note just how credible and strong this victim's testimony was. There was the issue with the son about the money. The timing that it came after his sister. Now his testimony was that he never told anyone because he didn't, he stole the money, had nothing to do with it. But once the mom told him it happened to the sister, his testimony was it broke his heart because he felt like it was his fault. Defense counsel was able to effectively argue to the jury, and I think maybe they found that a credible argument that you can't really trust him. He lied about the money. He's probably just lying about this. I mean, I think that the son had some problems in his testimony, although credible. He had some problems in his testimony that the daughter didn't have.
Well, in fact, the jury acquitted the defendant of some charges with respect to the daughter, correct?
Yes, they did. And Judge Locke directed out, I believe, lewd and lascivious. And then the jury did find not guilty on some of those charges. So the Commonwealth's position is that there was not error, that this was permittable in the context of the trial. It was permittable rebuttal. I have cited a couple of unpublished cases, I think, that distinguished Durgo enough that they were important enough to cite those unpublished cases. I think the fact patterns are similar to this case. But even assuming that the court, of course, found error, the Commonwealth's argument would be that there was just no prejudice here, that the defendant did not object, and that's an indication of how troubling this was or was not. The court gave an immediate curative instruction, which he broadened to all the witnesses. Judge Locke also gave instructions at the beginning of the case. He gave instructions at the end of the case. We presume that jurors will follow those instructions. The not guilties, which we have discussed, also go to prejudice. And I have to say the strength of this case. I mean, this victim's testimony, I cited the dissent in Alvarez, which I think is worth noting. And given the strength of this victim's testimony, there's no prejudice to this defendant. If the court doesn't have
any light you can shed on the wrong jury instructions?
Yes, so they discussed things quite a bit. There were a lot of charges, 27 charges here. That they had a chart, and I think everything was fine and everybody was on the same page, and they had discussed the correct charge. And when Judge Locke came out with his written instructions, I think it just got flipped. And at that point, they were at the end of a very long trial, and it just, he read his instructions. They did a charge and didn't I think my memory is that during the charge conference, they talked about the correct charge. And then when they came out, it just got flipped. And the difficulty was, I think, as my brother noted, the defendant could have been charged either way. It was child pornography and adults. So it was, the facts were there for that. So I don't think it jumped out. So it was unfortunate.
I wouldn't hold you to this, but what is the likelihood that the case would be retried on that indictment?
That's above my pay grade.
I appreciate that.
If the court doesn't have any other questions, I would rest on my brief.
Hearing none, seeing none, that will do it. The case is submitted. Thank you both very much.
Thank you very much.
Next two parties are here.
Let's do it.
Good morning.
ADA Lee, I'm assuming you've done the Zoom arguments before?
Yes. They seem to be moving smoothly.
Good morning, counsel. Can you hear me?
I can hear you, Warren. Can you hear me?
Yes, we can. Talking to the clerk, Matt, are we still online, or do we need to get back?
I need to go back online whenever you're ready.
Okay.
Okay, I'll let you know.
Ready.
The case is now being recorded.
Thank you very much. We're back on the record for our second case. It is 2019 P 1662, Commonwealth versus John Doe. I would remind the parties that the case is partially impounded and we should stay away from any names. And with that, I will turn the floor over to Mr. Noonan.
Thank you, Your Honors. May it please the court. Patrick Noonan for Mr. Doe. Your Honors, today we are just asking that this court remand this case back down to the district court for a further hearing on the merits of the case. This was a motion by Mr. Doe to seal a criminal charge out of the New Bedford District Court. That charge had been dismissed, and he had filed a motion to seal. And it's clear from the transcript that the parties had addressed this case under the stage 1 process of sealing a record, as opposed to the combined stage 1, stage 2 type of hearing on a motion to seal.
So counsel,
Yes,
do you agree that the standard of review is abuse of discretion?
I believe, yes, that it would be, Your Honor. The parties at the outset, I think the judge at the outset of the hearing had stated and clarified, this is on for stage 1. And Doe's attorney made it clear that he was only trying to present a prima facie case under the stage 1 process to pass the hurdle to
So
get to
counsel,
stage 2.
do you know how that happened? I mean, it seemed like the court's form was incorrect, but why did everyone assume there was a stage 1, stage 2 when PON is very clear? You could just have one.
Sure. And PON does not require a combined hearing. They just said that it's basically discretionary, that a court can decide which type of proceeding to go through. It's up to the court or the judge to say, we're going to do a stage 1 and then go to stage 2, or have a stage 1 and stage 2 together. It states in PON that it's, and they cited a survey from, I think it was the Boston Municipal Court, as to how courts treat these type of hearings. For example, I had a case in Taunton District Court, and they decided our process is we're going to do a stage 1 hearing, and the defendant makes his prima facie case. And if you do, we're going to mark it up for a stage 2. So I think the practice of the New Bedford District Court was to do a stage 1 and then stage 2. And I think that's why the judge, I think it was her practice to do a stage 1, stage 2. So since this was a stage, yes, Your Honor.
If the defendant had put in an affidavit saying, I'm making the exact same salary and I'm working the exact same hours, but I can't work on school projects, and those are desirable because they're long-term, would that be sufficient for a prima facie showing?
I think so, because the standard on a prima facie showing is very, very minimal. And the defendant did say, or his attorney did say, that he has not been able to work because of this criminal case. He did say he wasn't able to work on 2 specific jobs, but in the transcript, he had stated that since then, or since this case, he's been unable to work, and that this job with the cost of construction was his only potential employment. So I think he was saying he couldn't work at 2 jobs at schools, but then generally speaking that the case was prohibiting him from continuing to work at Costa Construction. So I think that,
counsel, I guess you've just hit my concern right on the head, which was that the affidavit itself was sparse, and then counsel was making representations at the hearing. So why should that be enough? Why shouldn't the Doe come in with a robust affidavit?
Sure, and I think one of the problems was that Doe's attorney really went in with the mindset of, this affidavit is enough to pass stage 1, and once I get through stage 1, I'm going to come to stage 2. I'm going to be ready to address the facts of the case, the merits of the case, and he'd go in on a stage 2 more prepared, because under stage 1 his threshold showing was so minimal. So I think that his affidavit, that Doe's affidavit was enough to get him past stage 1. And if you read Doe, they really go into great detail about the court can take judicial notice of the fact that having a record will really affect one's ability to get employment, and that the new legislation that came out was really geared toward getting people jobs and gainful employment. And it was actually sort of styled as like an economics bill, that we want to afford sealing to people so that we can promote getting jobs. So
Well, could I ask you this though, counsel, because you do say in your brief that basically Doe wasn't on notice that this was a combined hearing, or that there wouldn't be a stage 2 hearing. But the judge does say at Appendix 23, let's pick a status date. I'm not setting it up for stage 2. I haven't decided if we're going to have a stage 2. It's going to be on for status if I allow that, okay? So although it's not the model of clarity here, you could read that part of the transcript as putting you on notice that there may not be a stage 2 hearing. What do you respond?
Well, I see the biggest problem with this case is being that the parties treated this as a stage 1, and Doe's attorney was not prepared to discuss the facts of the case. And the judge really wanted to know about the facts of the case. Her only question during the hearing was, how old was the victim? That's important to me. And Doe's attorney said, we're not in a position to litigate the facts of the case. I am looking to have a stage 2 so I can have an opportunity to present that evidence regarding the facts of the case. And the district attorney made some representations about the facts of the case, but she admitted that she hadn't been able to review the entire file. I represented Mr. Doe on the actual case itself, the underlying case. And I would say that that case was a wrongful accusation. And if there were a stage 2 hearing, Mr. Doe's attorney at that time would have been able to get into the fact that this case was disposed of as that the case was dismissed for a reason that was very, very favorable to Mr. Doe. But it was sort of out in the air as to the judge was seeing that there was a complaint for an indecent A and B, which is a very serious offense. She saw that it was dismissed, but she really didn't know a lot about what was going on with that case. And I think that the judge denied this and did mark it up for a stage 2 because she was concerned about the charge, the actual charge itself, that was a sex offense. And, understandably, any judge would look at that and be concerned about not wanting to seal somebody's record. But the fact of the matter is, if you're going to deny a motion to seal based on the underlying case, there has to be some sort of discussion or hearing about what are the facts of that case and why was it disposed of the way it was.
Counsel, from a policy standpoint, though, the council's approach here, not yours, but the sealing council's approach seemed to be, let me make as sparse a showing as possible and see if I can get to the next level. Why should we encourage that?
It shouldn't. I would disagree that it was sparse. I think that it was enough of a showing to make a prima facie case. Because employment is the most important basis for getting a motion to seal. And he had enough in that affidavit to show that Mr. Doe's ability to get employment was affected by this charge.
So let's explore that. Does Doe not counsel? I don't care about counsel. Does Doe say I was unemployed? Because I don't see that.
You're right.
And does Doe say I made less money than I would have?
No. Doe says I have this job at Costa Construction and I'm prohibited from doing certain jobs due to my record. And those jobs are long jobs that would afford him more opportunity. So he was employed for the construction company, had worked, but this construction company does a lot of work for municipalities and schools. And in those circumstances with municipalities and schools, they're going to look at a criminal record and they're going to say, even though this is dismissed, you can't work on these jobs. So Doe could work for residential projects for masonry, but the bigger projects, the more long-term projects for municipalities and schools, he cannot do. So he's very restricted in terms of how much work he can do for the cost of construction. And one of the things that the district attorney, I think, had said was, well, he can get a job for another company. And I would disagree with that logic because he was with cost of construction for 17 years. If he just left and applied for another sort of construction job, he would have to undergo a background check, and it would be very difficult for him to get a new job with a new employer with having this on his record. So I think that the stage 1 threshold was met in this case, and it's a very low one. And this court takes judicial notice of how criminal records affect employment. The affidavit was sufficient. And if a stage 2 hearing was set up, then the facts of the case would be fully litigated. And
Was there anything that precluded his employer from filing an affidavit that said, hey, 85% of our work is at schools, and so he can only work on 15% of our jobs? Is there anything that precludes an affidavit like that?
No, an employer can certainly offer an affidavit to that.
And so, to Judge Henry's point, the sparseness of the affidavit is of some concern to me.
It is, and Mr. Doe did say in his affidavit that he spoke to Human Resources. Human Resources said you can't work on these projects because you're charged with a crime, regardless of the fact that it was dismissed. So,
just responding to Judge Blake's question, isn't it quite possible that there are practical reasons why that's not an option? For example, people paid either under the table or as independent contractors in the construction industry, and therefore they probably aren't going to get a favorable reception from their employers to get into the details of how they're paid, et cetera?
Well, I think that the Doe's allegation or claim that he spoke to Human Resources and Human Resources said you can't do these projects because of your record, I think that's enough to pass the stage 1 process.
Now, can we, time is getting short.
Sure.
Going from some of the procedural aspects to the underlying merits, isn't your real argument that the judge effectively applied the wrong legal framework by saying, well, this involves kids, the allegations involve kids, that's the end of it, I'm not going to have to do the balancing that Pond says is required?
That is absolutely what happened in this case, Your Honor. The judge made it clear she was looking at a stage 1 type of hearing. She looked at the argument by counsel, which was employment, but she was focused on the actual fact or the allegation being this is children, this is children, this is children. And the problem was that the parties couldn't answer her questions about what the facts of the case entailed. And I think that she denied this on an incorrect standard, because the stage 2, that's the point in time where you would really get into the merits of the actual facts of the case. She looked at the charge, saw that it involved children, and denied the motion as to stage 1, where she should have reserved judgment on that and addressed it at stage 2. And this was a case where at a stage 2, if we got into the facts, there were facts that were extremely beneficial to Mr. Doe. The judge never heard.
Counsel, what should we do if hypothetically we were to agree with you with regard to the legal framework, but conclude that the factual showing your client made was so thin that the judge could have denied it on that ground? Is there anything that is prohibiting your client from refiling such a motion with a stronger factual showing?
If this is something, and that's an excellent question, I don't have the answer to it, because I don't know if he's barred from reapplying because this was something that he applied for and was denied. I don't know if he's stopped from doing it going forward. But if he can reapply and do this petition again and then go in locked and loaded with all the evidence, then certainly we would definitely do that. But at this point, I think that it should be remanded back down for a stage 2 hearing on the merits of the case, because he made the showing to get to that stage 2 hearing. and I think my time has expired. So if there's any other questions, I would rely on my brief. Thank you, Your Honors.
Thank you very much. Seeing none, we will turn it over to the Commonwealth.
Good morning. May it please the court. Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. Commonwealth's position is that the defendant in this case did not make the prima facie showing, even though that prima facie showing standard has been greatly lessened under Commonwealth versus Pond. The defendant came in with a 3-paragraph affidavit saying he's the defendant. The statements made in his petition are true, and that he requests that the court grant his petition. It was not signed until they went in for that hearing, and he signed it in front of the judge.
So counsel, where the
In his
defendant eventually signed his affidavit, is it significant at all?
I'm sorry,
Is this the fact that he somehow submitted it unsigned in the first instance, but he did sign it at the hearing? Should we be bothered by that?
I think presenting affidavits unsigned in the district court is something that happened, at least when I worked in the district court, it happened with regularity. And then it was signed at the hearing, particularly in a motion to suppress. And I think that it was done primarily so that there wasn't a signed record until the defendant got a hearing. They didn't want a signed document by the defendant out there. And I get it. That's a strategy used by defense counsel. But it says something because he didn't sit there and read his petition at the hearing. He just signed this very sparse, bare bones, really couldn't say less than what he said in his affidavit right there. And then in his petition, it says he works full-time in construction for the named company. Now, his claim for sealing is that he is being harmed in his employment. Pawn was an OUI case. That's where the court changed the standard and it changed the requirement for 2 hearings. Doe, the SJC case cited in my case, Commonwealth versus Doe, in my brief, that was a sexual assault case that was null prost. And in that case, I believe that was prior to Pawn, but in that case, the showing wasn't sufficient. And I would suggest this case falls within Pawn. This is an indecent assault and battery on a minor, and the defendant's only claim is that he cannot work at public schools, one being an elementary school, which would be the age group of the named victim in this case. The victim claimed that it was an intra-family assault and that it began when he was 6. And then the other school that Mr. Doe wanted to work at was a high school. And so what he's claiming is, I should be able, my privacy rights, my right to employment, and the Commonwealth's value in my being employed, which is I'm not denying that. That's a big one. That's what's behind Pawn. We want people working. We want people invested in their lives and communities. And so this is a good process for sealing. But he's saying those values, the Commonwealth's interest in him having a job and his interest in privacy and his interest in his working at public schools without the school administration knowing his history is more important than the public's right to have open court records. And that is the balancing test.
One of the things I worry about, though, Attorney Lee, before we get to the affidavit, and I don't think your brother would argue that there certainly could have been a more meaningful affidavit. I'm troubled by the transcript of what Doe thought was going to happen, where they were in the process, and then ultimately what the judge decided. At best, it's unclear what this particular judge thought she was doing, or at least represented to the party she was doing. And then the result when she signs the denial later on, there's some inconsistency there, so that even if I were to agree with you on substance, the process is troubling to me. Can you speak to that?
Yes. So Doe's counsel went in citing Pawn, and Pawn removes the 2-step process. So being,
in order to make it easier for a defendant.
I understand. And so he said, I'm viewing this as a first hearing, and the court did not dissuade him of that until the end, where she said, I'm not saying whether you get a second hearing or not. So if this court finds that the defendant has made his prima facie showing, then the remedy is to go back for the substantive hearing. Yes, it's not
And
to
the-
see records.
The
And
judge
then,
checked a box on the petition, and I apologize, I don't know this. The statute doesn't require her to make findings?
I think the findings are required when sealing is done.
Okay, so at record 4, she checked the box, or 14, I should say. After review, the court finds no prima facie case. That's sufficient in terms of her obligations from the statute.
Yes, because you only get your records sealed when you've made your showing
Okay.
and the balancing strikes against the public records. Because it's a very strong public record value for the Commonwealth, as well as the rehabilitation of criminal
No, but
defendants.
I understood, counsel, but tell me if I'm wrong. The judge does not appear to have said you didn't make your prima facie case because your affidavit is just too thin. It doesn't specify what the harm would be, what the actual harm is to you. Instead, the judge appears to have said, again, we don't even get to balancing because, you know, we're dealing with kids and we're dealing with an allegation against kids. End of story. And
You are
if
not
that's
wrong.
what
That's correct.
if the judge did that, isn't that wrong?
So I think, to try to speak to that, I think in an ideal world, the judge would have reminded counsel at the beginning, you don't decide whether there's a stage 2 hearing. I decide. You have to make your prima facie showing. And that would have put him on notice for that point. I suggest, having cited Pawn, he's on notice for it because Pawn talks about that. And she does tell him at the end of the hearing. And my understanding under Chapter 276 is that the written findings are required because you're changing what is a public record into a sealed record that nobody can get to. So I think her findings are sufficient. And speaking to a question that was raised to my brother, I don't see anything in Chapter 276 that prevents another request. Chapter 276 is the sealing statute, Section 100 and following statutes, sections. I think you can bring another request, particularly.
But why wouldn't it be collateral estoppel? I mean, you'd have to have something new, right? I tried to get another job and I still couldn't get it. On these facts, you think he can bring another petition?
I think because his facts are so lean, I mean, he could really offer any information just that he is not getting paid. I mean,
I know that you say Pawn is the reason that the defendant was on notice that this might not be a stage 1 hearing, but at record 17, they call the case and the first thing the judge says is, all right, so this is just stage 1, correct? And defense counsel, that's correct. How do I balance that with Pawn?
So it shows they're not following Pawn. They should have had a discussion about Pawn there if they weren't clear on it. I think the judge was trying to note that she's looking at the prima facie stage. Have you made your prima facie showing? And then counsel during the hearing tries to substantiate the claim in his argument, saying he hasn't been able to work for months, but that's an unsworn statement. That's not part of the prima facie showing. So if that's true, I mean, all the defendant has to do is put that in his affidavit. And to the extent that that's not true because he's being paid in a manner he doesn't want to report for whatever reason, I'm not suggesting that about this particular person, about construction people generally, just that was brought up earlier. If he can't make it because he's actually making money, well, then he can't outweigh the balance of the public record requirement. So
No, that counsel, you've misinterpreted my point, which is that the HR may not be particularly helpful to him because they don't want to get into issues of how he's paid. I mean, there are parts of your brief that have sort of the tone of, because the affidavit was so sparse, for all we know, even though he can't work on all these important jobs for his construction company, he's receiving his entire salary for just sitting at home. Needless to say, that's not how the construction industry works. And, especially where we're talking about stage one, there is an affidavit, albeit a bare bones one, talking about what he can't work on. And the attorney is making representations in open court. Why wasn't there enough to get over stage one here?
Well, I apologize for misinterpreting your earlier comment. I don't know that's how the construction industry works, because it's not in his affidavit. So he needs to tell the court, I'm harmed. That's the harm to him is what gets him over the burden.
But why isn't that a reasonable inference from the affidavit?
I think it's, and I apologize, perhaps it's just poorly written, but I think it's conspicuous by its absence. Why isn't he telling the court he's not getting paid when he writes in his petition that he's working? He has the burden. It's not a heavy burden. You just have to say you're not getting paid. And he didn't say it. And I don't know.
But again, the judge didn't say, he didn't say this, and therefore he doesn't get over stage one. She said, I think it was a she.
Judge Rayburn, yes.
It involves kids. End of story.
So I think she moved along to the analysis in Pawn that the interest of the Commonwealth in protecting children is so high that his showing wasn't sufficient to meet that and wouldn't be sufficient to meet that at a later hearing, even if he wasn't working. And that's supported by Globe Media, which I cite in my brief, which is that person working for the Commonwealth has a lesser privacy interest. Globe Media is a public records case.
No, I understood, but we don't know whether or not a Mason on these school projects, for example, would ever have any one-on-one contact with any children at the site, and that would be a very relevant point for a balancing test, wouldn't it?
You're correct. We don't know that, but what we do know is it was important to the school that even a dismissed charge means he's not going to work there. So if it's important to the school that takes care of the children, then what he's saying is you should hide this information from public school so that I can work there without the school even knowing, without the school being able to put in any restrictions on me, because they will be blind to that information. That's what
why do you think that's coming from the school and not from the employer?
I understood that it was the background check when he was trying to work at the school. Did I misread his petition?
I don't know. I took it as the employer. I mean, it's not clear to me that if he gets his record sealed, he's going to be working at schools. Because if you're an employer, you're taking on arguably some liability risk.
Yes.
I mean, it's certainly a case that would be argued. It'd certainly be an interesting case. I guess I'm struck though about the difference between your reading of Pawn and defense counsel's reading of Pawn. I mean, I think Pawn is unfortunate in that I don't know that the average person who wants their record sealed would apply for 300 positions, or even 50 before they moved for sealing. So we can't use that as the benchmark.
That's not required anymore. Yes.
Right, but you say, that a bald allegation of inability to work or underemployment is not sufficient, and I can't figure out exactly what language you're relying on page 319, but I do see that at page 316, the court says the defendant must allege with sufficient particularity some disadvantage. And here he has said not getting steady work. I don't think any of us are in the construction industry, but I'm guessing that between us, we have about 100 years of experience dealing with contractors. And first of all, if he really is a licensed in his trade, I'm being general for his own privacy, he would be you can't get someone who's licensed in his trade. He could be employed full time, but it'd be a little project. But he's saying I've missed this steady work, which takes a lot of stress out of life to not be going project to project. So why is that not a disadvantage under the language of Pond?
May I answer? I see my time's expired.
Yes.
So I think what I was trying to say in my brief is that the defendant can show that he's been disadvantaged, but that doesn't outweigh when the Commonwealth has an adverse consequence to it in the community. And that's in that adverse consequence language is at page 315 in Pond. And I would suggest that his affidavit here was woefully short. And if this court feels the judge was wrong, then it should go back to a stage 2 hearing.
I don't see any more questions from my colleagues, so the case is submitted. Thank you both very much.
The case is now being recorded.
Thank you very much. We are back on the record. Our apologies to the viewing public, if there is any. We had some technical issues we had to work out. The next case is Commonwealth versus Alves, 2019 P1019. We will hear first from Attorney Riley.
Thank you, Your Honors. If it may please the court, my name is Catherine Riley. I represent Mr. Tyrell Alves. We are here on the appeal of the defendant's denial of his motion to withdraw his guilty plea out of the Suffolk Superior Court. The defendant's motion was based on the complete ineffective assistance of the defendant's counsel at the time of his plea. It was so complete, it was to the degree that when the defendant stood in the Suffolk Superior Court on the time of his plea, he had no knowledge of who his 4 accusers were or of any defense he could have brought at trial.
Now, focusing on the identity issue, it's my understanding that he now knows the names of the accusers, but I'm having a hard time seeing the showing of what the prejudice was for his not having known the names of the accusers at the time of the plea.
Sure. The lack of any knowledge about his accusers meant that there was no meaningful investigation prior to his plea, that his counsel didn't discuss who his accusers were, why they were accusing him, where they came from, anything with the defendant. What his counsel focused on was disposing of the case prior to trial. So there was no investigation. What there was preparation for disposition of the case. So that left him standing before the court, making a plea, having no knowledge about his own case. He was never given any of the written discovery. His defense attorney claimed that was because he was prevented from providing that information to the defendant because of a protective order that plea counsel actually agreed to and enforced. Just turning to the Commonwealth's brief regarding claims of ineffective.
There's an indication that Dr. Rin's report refers to video evidence. Do you know was there video of at least some of the alleged conduct?
Yes, there was video evidence of the scene of where the alleged conduct occurred. Some of it was exculpatory, not matching up with some of the complaining witnesses' statements. It wasn't until Dr. Rin analyzed that evidence actually in his report to the court, pointing out the discrepancies between the complaining witnesses' statements and the statements, and the video. But however, the defendant was not privy to Dr. Rin's report. He never received Dr. Rin's report until post-plea. In fact, he wasn't privy to anything in Dr. Rin's report, including his determination that if the client chose to go to trial, a jury may believe that he was lacking in criminal responsibility.
So I want to make sure I understand your argument. I think you're saying you don't need to show prejudice because defense counsel basically abandoned his role as an advocate and substituted his judgment for the judgment of the defendant. Is that right?
I'm saying both that and that there was prejudice. The prejudice here is that it was complete prejudice. It wasn't just the lack of one defense, like knowledge of the doctor finding a lack of criminal responsibility. It was lack of knowing any possible defense, including just putting the Commonwealth case to the test at a jury. The Commonwealth's evidence was statements of young girls that alleged him of this conduct. However, one of the charges was assault with intent to rape. And it was really unclear from the statements in the discovery what exactly led to that level of crime. Had this been put to the test of a jury and their evidence been tested against cross-examination, that might have failed. That charge might have failed. But
and if he had been convicted, counsel, he was facing a huge sentence. I mean, essentially, he got 30 more days than he was already serving for all of these sex offenses.
You know, to plead guilty to these offenses might have been a reasonable choice if, in fact, he was guilty. And that's the only time pleading guilty to these types of offenses is reasonable. But also that, so I think the trial court's decision refers to this, the decisions that plea counsel made as tactical and strategic. And they cite a Commonwealth versus Kolenovic. The difference between the facts here and the facts in Kolenovic was the defense attorney in Kolenovic discussed defenses with his clients. He discussed those defenses. His clients agreed to his strategy and the tactic of pleading guilty or not bringing that defense in that case. Here, there was no discussion with the defendant of any defense. The prejudice is complete. He did not know he had any defense. He did not know he had the right to know his accusers' names or their information. He did not know he had the right to have the reports in front of him and review them, which was particularly important in this case where a doctor found that his verbal comprehension was below normal. So everything the defendant heard, he was not comprehending on an average rate. His defense attorney knew this, but he did not because he was never privy to Dr. Rin's findings. What I think, you know, turning to a quote in the Commonwealth's brief, they quote Commonwealth versus Satterfield, where it says a conviction will not be reversed on this basis, referring to ineffective assistance of counsel, unless the defendant can show that better work might have accomplished something material to the defense. What that quote leaves out, what the Commonwealth brief leaves out, is the next sentence in Commonwealth versus Satterfield, which states, an exception might be indulged where the defense was so botched that the judgment on that hypothetical question would be without value. And that's the situation here. It wasn't just botched, there was no defense. The defendant repeatedly claimed his innocence to plea counsel. In fact, plea counsel refers to the defendant's letter writing campaign to him at a lobby conference that the defendant was not privy to. And despite those repeated claims of innocence, he mounts no investigation into the client's innocence. And the only thing he does is start to dispose of the case. And it's from day one, he leaves his client out of each and every critical decision.
What kind of investigation are you saying should have been done?
Well, first of all, a discussion with the defendant. over the complaining witnesses and what happened and what didn't happen. I have no record of this letter campaign of the defendant to his own counsel proclaiming innocence because plea counsel refused to give over his file. But what first should have happened was a discussion with his client of where he was, what he did, who he knew, who he didn't know. Then there should have been an investigation into the complaining witnesses. This is 4 different complaining witnesses. There was no investigation. What there was preparation for plea. And that's why he hired Dr. Rinn, was to prepare for plea. What he hired Dr. Rinn was for a sentencing memorandum. But what Dr. Rinn was is a doctor in neuropsychology, and he analyzed not only the defendant's background, but also determined that there could be a defense of lack of criminal responsibility. So knowing a doctor said that, he did not discuss that with his client, and he did not further investigate that possible line of defense.
And we only know that because of your client's affidavit, right?
Yes, and that goes to another point. I think the Commonwealth refers to, I believe it was Commonwealth versus Gordon in their brief that states that the judge could not allow a motion to withdraw his guilty plea based solely on the affidavits. And that's not exactly what Gordon says. In fact, Gordon says that the judge's ability to allow solely on the affidavits is limited or circumscribed is what the word they use. But that a hearing when a substantial issue is presented is what should happen. And not only was there no hearing, there's no findings of fact in the judge's decision. There's no section that says what fact he agreed upon or what he did not. The decision is based on saying that this was a reasonable decision by defense counsel, strategic and tactical. The problem is the defendant was completely left out of it.
What, if anything, can we infer from the lack of an affidavit from plea counsel?
I don't think you can infer anything. I don't have it in front of me, but there's a case cited that if there's diligence in trying to track down plea counsel, then that should not be held against the defendant. And I can provide that with the court if needed. I was the motion counsel. I spoke with plea counsel. He first, and it's in the affidavit of counsel in support of the motion, he first agreed to give his file over, then hesitated, then agreed again, then eventually said no, just flat out no. Then post saying flat out no, said that his file was destroyed in a flood.
Can you pivot for a second to the defective plea colloquy? Can you address that issue?
Yes, I would like to do that. So the Commonwealth actually provided supplemental case law yesterday. This is a factor. The defense is not claiming that the defective plea colloquy in and of itself invalidates this plea, but it is a factor to take into consideration in this particular case where you have a client who is intellectually and cognitively disabled, who a doctor, a doctor determined that his verbal comprehension was below normal, that he suffered from intellectual disabilities from a head injury as a child. So you combine that with the ineffective assistance of his plea counsel, who did not inform him of the details of the accusations against him. And then you combine that with the plea colloquy that leaves out substantive rights.
Well, but in no way. Let's focus in on that, because there's a lot that was said during the plea colloquy and that the judge asked, as he's required to do. Did your client understand that?
I don't know. The doctor's report suggests that verbal comprehension is minimized on him. He didn't understand that he had those rights because his his defense attorney never explained those
What
rights.
about the waiver
never-
of rights form that he signed?
Yeah, that is not the same in going over the written discovery of the evidence against him.
No, but I'm asking you about the defective plea colloquy. And if you say he's not a great verbal learner, he doesn't take in information well verbally, he did execute a written waiver of rights form, and that was in writing.
Correct, but he did so without the effective assistance of counsel. He did it without any assistance of counsel. His attorney from day one on arraignment worked with the Commonwealth. So this goes to the second half of my brief. I do think that he suffered the ultimate prejudice, not being told about any defense. But this is a structural defect. We have a defendant in this Commonwealth that stood in front of a court not knowing who his accusers were and entered a plea. He did so with a plea attorney that only worked with the Commonwealth to dispose of this case as efficiently as possible. He had a right to the assistance of counsel. He had the right to make his own decision as to whether to plead guilty or not. That was not a decision his counsel should have made. It should have been made knowing the charges against him, knowing who his accusers of, and knowing possible.
So let me just ask you, because your time is almost up. If we were to reverse, does this affect his SDP status?
That's unclear. I don't believe it does.
And to the extent that you're arguing that the problem here is the turning over of the psychologist's report that was then used against him in the SDP proceeding, why isn't that an issue that is properly raised, if at all, in the SDP proceeding and not in this case where, from all appearances, it served him to great advantage on the sentencing?
Well, it only served him to great advantages if he was going to plead. So it was just another aspect of his plea attorney putting something to the court to effectuate a plea. The client had been writing to his attorney pleading his innocence. That report only made him look guilty and actually a candidate for recidivism. If he had gone to trial, he would not have wanted to turn over that report unless he was going to claim lack of criminal responsibility. But he had no part in that decision. He was unaware of that report's contents until after his plea. The decision to turn over that report should have been made after it was reviewed with the client and the client decided he wanted to plead guilty.
And those facts are established in the affidavit?
As best they can. There was no hearing on this motion, despite a request in the original motion and despite a follow-up motion specifically requesting a hearing.
Do either of my colleagues have any follow-up questions? Seeing none, thank you very much, counsel. We will hear from the Commonwealth.
Thank you.
Good morning, Your Honors, and may it please the court. Erin Knight on behalf of the Commonwealth asking this court to affirm the denial of the defendant's motion to withdraw his guilty pleas. I'll start with the ineffective assistance of counsel claim and the names of the victims. I think here the question really is, what was the prejudice? The defendant has since been informed of the names of those victims and has not alleged anything further regarding the names of the victims. No defense, no even possible line of defense regarding those names. I think it is very telling that the defendant admitted to the date of the acts, the times of the acts, and the actions he took in commission of these offenses when he rendered his plea of guilty and admitted to those facts. So I think the names of the victims here really did nothing to change the direction of this case.
But what about his decision to agree to the protective order without, at least as the defendant tells us, without consulting with his client?
Sure, and yes, Your Honor, I would also point that we are relying, the court only had the defendant's self-serving affidavit in front of him regarding what did happen before the plea. But turning back to that, the the concept of a protective order is not unknown to this Commonwealth. I think especially in cases of sexual assault, attempted sexual assault, and in cases of young victims. Here, these victims were young girls that were unknown to the defendant. So a protective order here was certainly not out of the question, and in fact was fairly reasonable given the actual situation at hand. So I think the fact that he did not know the names of these accusers, again, does nothing to negate that he admitted to committing these actions on these dates at these times.
So counsel, these were supposed to be, or alleged to be, just assault on strangers on like public transportation, is that right?
Generally, yes. I think there may have been a little bit of information that one of the victims may have seen him before or known him from the area. But generally, these were young women, I think ages like 13 through 14, around that area, that were generally unknown to him on both MBTA buses and around those areas, like exiting the station.
And where his plea counsel's not cooperating, is there a mechanism for him, short of having a hearing and subpoenaing plea counsel, where the plea counsel, either refuses to turn over his file or now says the file was lost in a flood?
Sure, and I do want to give credit to Attorney Riley. She clearly did do a lot of work to try to get that affidavit. So I'm not trying to say that, it's of any fault of her or anything like that. But I think, the affidavit still has to raise a substantial issue, and that's the burden the defendant bears. How he goes about doing that may change depending on his given situation. And here, looking at his affidavit, especially in terms of the ineffective assistance claims that he raises, it just does not reach that substantial issue warranting an evidentiary hearing here.
Counsel, can you turn to the psych report?
Sure.
And the handing that over to the Commonwealth, because one can view that as having been of great assistance to the defendant, but one does not have to view it that way. And one could see it as, this is a pretty damn big deal, and shouldn't he have at least talked to the client before he revealed something so serious and otherwise confidential?
Sure, Your Honor. And I think, again, I just want to point out that the only evidence we had that the defendant was not consulted what is his own affidavit.
Because the defense counsel wouldn't.
Understood, but that the proposition still stands. And I think also it is very clear from this record that he was given a great benefit due to sharing that report with both the court and the Commonwealth. The Commonwealth took it into consideration.
How long has he been locked up as an SDP?
Your Honor, I'm sorry, that is not information that I have. The SDP is done separate and apart from anything that I have involvement with, but I do know that he was, I'm sorry?
If you take into account the potential collateral effects of turning over that report, he may not, in retrospect, think it was that good a deal.
Well, Your Honor, I would just highlight that what was said earlier, that his sentence here, 2.5 in the House, which, by the way, the judge was looking at state prison time before being given this report. So this report really did mitigate his sentence down. So that's a huge benefit that he received. And then he nunc-pro-tunked it back to run concurrent with a quaff that was violated out of Somerville for like offenses. So I think that technically this defendant was still facing SDP consequences. So I don't know that necessarily this particular report has anything to do with what any collateral consequences SDP wise. I know it was used in the Commonwealth's by the Commonwealth's reviewing physician when she evaluated him for SDP, but I would also highlight that it was just used in that review. It was not the review was not based on that. So I think, give and take here, he received a huge benefit at the beginning by use of that report. Had the judge not had that report, again, he was looking at giving the defendant state prison time. So I think
on
that
point, the judge did in his colloquy advise him of the potential for an SDP proceeding, right?
Correct, Your Honor. And he signed the written waiver.
And let me ask you, I recognize that you weren't the lawyer on the SDP, but even with this report, am I correct that the Commonwealth would still need to have 2 QAs to say that he was SDP in order to move forward?
I'm not sure of how many. I'm sorry, SDP is not my specialty, but I do know that you do have to have an individual evaluation at the time that the defendant is being considered for SDP status.
So there's no question, if this defendant was on board with a plea, he got a good deal. I don't even think Attorney Riley objected to that sort of general proposition. I think her issue is, and it's something that's troubling me, he didn't, at least on his papers, he makes the argument that, yeah, it might be great that I got a plea deal, but I didn't know I had a choice. I didn't know what my trial options were. I didn't know what I could do or not do relative to perhaps a criminal responsibility. And for that reason alone, I should be able to withdraw my plea. What do you say about that?
Well, I would say that the defendant first doesn't actually allege any lines of defenses that he is missing out on due to this plea, due to the ineffective assistance that he claims. His affidavit doesn't allege any direct line of defenses except the possibility for criminal responsibility. And it's clear from the record that the plea counsel here took that into consideration. In his experience, plea counsel told the court that in his experience, criminal responsibility, if the defendant was to pursue that at trial and found not guilty due to criminal responsibility, he was still facing the possibility of a lifetime civil commitment for winning his case based on criminal responsibility. So looking at the options that were in play here due to the evaluation, I think taking the time that the judge agreed to nunc-pro-tunc back was much more, I guess, tactical and strategic than defense counsel would like to paint that picture.
But does defense counsel get to make those tactical, strategic decisions without consulting with his client?
Again, Your Honor, I wouldn't go, I don't agree that the client was not counseled at all. The defense counsel stated multiple times in both the lobby conferences and the day of the plea that he had been in talks with him. I do recognize that he had said that he had been receiving letters from the defendant, but he originally said he wasn't sure if he could get him to plea. So there were obviously talks with the defendant because the defendant ended up agreeing to plea. And if you look at the colloquy, the overall of the colloquy, yes, the presumption of innocence language is missing, the self-incrimination language, but again, there are cases that say that those omissions aren't necessarily fatal in and of themselves. Non-compliance with Rule 12, especially 12C, is not fatal in and of itself. If you look at the entirety of the colloquy, the defendant was informed of his right to a trial. He was informed of the Commonwealth's burden of proof beyond a reasonable doubt. And he was asked multiple times, did you consult with your lawyer? Do you think he's given you sound advice? He agreed to all of these warnings and the SDP
so it's
warning as well.
possible that we could say that the defendant has met his burden with respect to prong 1, but can't show prejudice.
Absolutely, if that is the route that the court takes, because I don't believe there is prejudice here where he received such a great benefit. I just don't think can be negated. I think that is a huge factor here.
Counsel, why isn't the issue that we're really facing, should he get a hearing, not does he get a new trial?
Because I just don't think that the substantial issue is raised. And what would be, at this point on this record, I think everything is sussed out from the record here. And if the court were to hold an evidentiary hearing, there really isn't much more that can be found, I think, on this record that could be.
No, but that's the point, because the record would include, for example, presumably, the testimony of plea counsel who would get into all this. Did he ever share the report with the guy before the plea? Did he discuss?
There is that possibility, but I think it is also appellate counsel's inability to get an affidavit from him might not be based on the fact that he didn't want to give it. It might be based on the fact that I think his words were he doesn't do that. It might be the fact that he does not agree with how the defendant remembers this case.
Right, but counsel, as a system, why should we allow a defense counsel to just say, I don't do that?
I think that's, I can't speak to exactly what he meant by that or his intentions, or really, anything but what's in Attorney Riley's affidavit. I think that here, on what the defendant had presented before the judge, who was also the motion judge, who was also the plea judge, who understood this case, who took everything into consideration. There were lengthy discussions about this case. He knew what was going on. He knew the facts of the case. He knew the evaluation.
When you say he, you mean the judge, because the defendant was not in any of these lobby conferences.
Correct, Your Honor. The plea judge, who was also the motion judge, had all of this before him, and understood this, had been with this case for a while and understood this case. And I think given his memory of how things played out, he did not warrant that there was a substantial issue raised warranting an evidentiary hearing. And again, it's an abuse of discretion. And I think given that he was in fact the plea judge and knew how this actually played out, that was certainly not an abuse of his discretion to deny the defendant's motion.
Would you speak, I know you don't have a lot of time left, but to the structural error claim by your sister?
There just is no structural error here, Your Honor. The structural error would result if there was absolutely no assistance of counsel here, and I think that just cannot be claimed on this record. It's clear he got a huge benefit by the defense counsel's tactical use.
Wait, counsel, if in fact a defense counsel substituted their own judgment, didn't tell the defendant the names of the victims, which seems undisputed here, did not share the report, this is hypothetical, did not share the report and decided this is a great deal because it was a great deal, and didn't really let the defendant make those decisions because he's, got some cognitive issues. And if, I'm not talking necessarily about this case, but if those things happen, wouldn't that be structural error? If he substituted his own judgment and didn't let the defendant make the decisions?
I think you need more information than that. And I say that because first and foremost, I just want to point out that the defendant here has graduated high school. He's worked multiple jobs. So his cognitive issues don't necessarily impair him from understanding what went on. And I think that here, where defense counsel had previous experience in criminal responsibility, again, Dr. Rinn was not tasked with a criminal responsibility evaluation, and defense counsel made that clear. Those were Dr. Rinn's own kind of spontaneous additions to his report. But I don't think that here we can necessarily determine those facts based on the defendant's own affidavit. And the judge was free to credit or not credit the defendant's affidavit as he so chose, with his knowledge of how the case played out. And as far as structural error goes, the fact that defense counsel really did take into consideration the defendant's intelligence, the defendant's how things were playing out in terms of his sentence beforehand. Defense counsel actually asked that his sentence be nunc-pro-tunct all the way back to arraignment. And the Commonwealth obviously objected, and the judge didn't do that, but he did give him a substantial, obviously a substantial nunc-pro-tunct time. And I think even if the defendant's affidavit is taken as true, he's still parts of it as true as to not understanding or not knowing the names. There are also a number of contradictions with his first letter to the court. And I see that my time is up, if I may finish briefly.
Yes.
His original letter to the court stated he did get to read the grand jury minutes at the beginning of this case. And then in his affidavit before the court now, it states that he never received the grand jury minutes. So I think contradictions like that also give a little bit of weight, whether or not the self-serving affidavit should be taken as accurate or should be enough to raise a substantial issue warranting a hearing. And again, this is an abuse of discretion standard based on a judge who was familiar with the case.
Okay, I asked my colleagues if they have any further questions. No, thank you both very much. Very
Thank
interesting.
you, Your Honors.
Well argued by both sides.
The case is now being recorded.
Thank you very much. We are now back on the record for our fourth case of the morning. It is 2019 P 1332, TAM versus Federal Management Company, Inc. and others. Mr. Golder.
Yes, may it please the court. My name is Frederick T. Golder, and I'm appearing on behalf of Ms. SIEW-MEY TAM and Ms. Raymond in their claim, the statutory claim and common law claims for overtime pay.
Okay, could we just stop for a second? We're getting feedback here. Does anyone have a second device on this? Could we just stop for a second? We're getting feedback here.
Somebody's got the live stream playing.
Well, let's
Live stream playing.
Yeah. Does somebody have YouTube on?
I can assure you that we do not.
well, let's try it now. We will make up your time at the back end, Mr. Golden.
Are we all set now, or?
Yes.
That remains to be seen. Go ahead.
I'm so grateful for the opportunity to address you in this kind of unusual situation that we're all in. Let me begin again. My name is Frederick T. Golder, and I am proud to be representing SIEW-MEY TAM and Ms. Raymond, Mary Jane Raymond, in their claim for overtime pay. And this class action was brought by those two ladies. And it's kind of interesting because my 50-year career advocating for the rights of workers, I was generally always in a situation where I had the burden of proof. But in these wage and hour claims, it's actually the defendant employer that has the burden of proof. Once I establish that they've worked more than 40 hours in a work week, the employer has to pay them time and a half for every hour they work over 40 hours in a work week, except if they can prove an exemption. Now, in this case, the only two exemptions that could possibly have applied would be the administrative exemption and the executive exemption. Now, for people—
Before we go there, Mr. Golder, could we talk about the deposition?
Of course.
Okay, so oftentimes in a deposition, you start out by agreeing to the usual stipulations, which includes the fact that if the deposition is not signed with an errata sheet within 30 days, it's deemed signed. Were the usual stipulations in place in your client's deposition?
No, we actually made stipulations that she was going to read and sign it. But the problem with that, Your Honor, is that the deposition has to be completed before that comes into play. And this—
Before we do that, though, when you say the stipulation was that your client would read and sign it—
That's right.
what timeline was that to happen in?
It has to happen after the deposition has been completed.
Where does that come from? Your principle that it can't be suspended for the clock to start running.
It comes from the statute. I'm sorry, when I say the statute, it comes from the rules, and it also comes from case law, that the deposition has to be completed. Because what happened, Your Honor—
Give us a specific case or a specific rule, please.
Okay. Forgive me, I have to get into my brief here to find it exactly. But it's the rule involving depositions.
Now, Rule 30E is what you're thinking of, but it doesn't say anything about the deposition has to be terminated. It speaks in terms of the full transcript. And I assume you're trying to tease out the concept from that language. Is that right?
Not teasing out, Your Honor. There's a case that I also have in my brief that essentially says that the party has to have an opportunity to respond to the cross-examination. That's what a deposition is. It really is to try to limit, or at least to limit the amount of testimony to, and what happened in this case is it was suspended. She never got an opportunity to tell her side.
But counsel, at the conclusion of the direct examination by federal at the deposition, you are correct that they said, okay, technically we're going to suspend it for these reasons. They then turned to you and invited you to cross-examination. to cross-examine her. At that point, you said, no, we're going to hold all questions till trial.
That's correct.
Then, and keep in mind, the admissions, at least if you read them as admissions that your client made in the deposition, are fairly dramatic. You were presented with the transcript of this session and did not do anything with 30 days. Why, given the at least potential dramatic impact of the specific admissions that your client made, why shouldn't we require under the rule that any errata sheet be filed within 30 days of receipt, even though, strictly speaking, the deposition was suspended? Your
Honor, the statement she made in the deposition transcript, and that, believe it or not, there was only about 10%. 90% of it was accurate. 90% of it did not need to be clarified. It was clear. There was one problem there, but you have to understand, Miss Tom was not born in this country. English was not her first language.
She taught English as a second language.
Yeah, she did, and she was very effective. In fact, she taught it to maybe half the people in Chinatown. But be that as it may, there were two things I did not know during that deposition. And one of the things I didn't know during the deposition, and I understand it much better now, but the culture of the Asian women are not the same as the culture of the American women. And they were very subservient to the males in that cultural environment. And the other thing I didn't know at the time of the deposition when, and by the way, Mr. Attorney Perlman questioned her in a way that was incredibly offensive. I did not know at the time that Miss Tom had been involved in a very abusive relationship with her husband. And she was intimidated by the questioning of Attorney Perlman. And you can't really tell from
But counsel, you could have suspended the deposition and gone into court and got an order relative to Mr. Perlman's behavior.
His behavior was not so bad. And remember now, it's not how I took the deposition. It was how Miss Tom took the deposition. I was not abused by my spouse. She was abused by her spouse, and she was intimidated.
Counsel, accepting arguendo, everything you're saying is true.
Yes.
Doesn't that even create a greater premium on immediately trying to correct the rather damaging answers that she gave at her deposition?
I did, but nobody listened. That's the problem. I did. I explained that she was intimidated. In fact, when we went to the hearing before Justice Ames, I explained to Justice Ames that he questioned her in a way that intimidated her. He gave rapid fire questions. I want to tell you, Your Honor, I have been trying cases for 50 years, and it's not difficult for a skilled trial attorney to confuse, to befuddle, put answers in the witness's mouth. Particularly, Attorney Perlman is a very tall man, and my client, Miss Tom, is a very small, diminutive woman, and she is terrified, and she told me how she was terrified by his intimidating conduct. And you can't tell that from a transcript. That only represents a very small part. You don't see the body language. You don't see the tone of the voice. You don't see the fact that Mr. Perlman had his client in the room, and the purpose was to intimidate her. He wasn't interested in the truth. Remember, Justice Brieger found a class action because it was really not that difficult.
Found a class action, counsel.
Yes.
It found a class action based on an affidavit that is phrased in lawyerly generalities.
Not at all, Your Honor. That affidavit was based on information provided by Ms. Tom, and it was confirmed by the other class representative, Mary Jane Raymond, who pretty much had the same job that SIEW-MEY TAM had, testified at her deposition. She was an American woman, wasn't abused by her husband, and she testified exactly the job that she did. And it was consistent with Ms. Tom's deposition, most of her deposition, and it was consistent with her affidavit. Ms. Tom told the truth to me And that affidavit reflected the truth that Ms. Tom told me. What happened at the deposition was the intimidating language, the approach that Attorney Perlman took. He knew that he was in trouble because.
How long after the deposition ended that day did you bring to the court the issue that your client was intimidated by Mr. Perlman's size, his questions, that she had been the victim of domestic violence, that there was a cultural issue with respect to how she went forward in her deposition? When is the first time you brought that to the trial judge or the motion judge?
May 21.
Of what
Less
year?
than a month of 2016. It was the first opportunity I had before a judge. We were there actually.
And so how long after the deposition ended for the day did you bring that to the court?
Within 30 days, but I did it even sooner to tell.
So why no errata sheet within those 30 days, setting out exactly what you've just described to us?
Because the deposition wasn't completed. The deposition, if I do direct examination, I don't get involved until after the cross-examination is completely done. When the cross-examination is completely done, I get to recross. That's how trials work. Same thing with depositions. It's no different. I don't get to do anything until he's done with his questioning.
Are you saying that when he invited you to do cross-examination, you were prohibited from doing that?
I'm not saying I was prohibited, Your Honor. I'm saying that's not the way it works. The person finishes the testimony at the trial. I then get to do my cross-examination. They do their redirect examination and recross. You don't do it piecemeal, Your Honor. That's not how trials are conducted. That's how depositions should be conducted as well. But more importantly, the fact that she had statements that were contradictory or appeared at first blush contradictory doesn't mean all they are prior inconsistent statements. They're not binding admissions. The case law is really clear on that. They are not binding admissions. They're simply inconsistent statements that Attorney Perlman could use at a trial. He can't make them binding admissions, but he did. And that's the sad part. He convinced the court to treat them as binding admissions. And go ahead.
Counsel, say hypothetically, we were to conclude that you did not comply with the procedural requirements of Rule 30E in terms of filing an errata sheet. What do you do then with the so-called sham affidavit rule, which does say we're not going to let a party deponent contradict her testimony? So in effect, taking them as binding admissions.
It's not a binding admission, and I'll tell you why, Your Honor. It's a prior inconsistent statement, and in isolation, yes. But in this case, I had another class action representative, Mary Jane Raymond, testified in her deposition. She signed her deposition because the information contained in that was accurate, consistent with SIEW-MEY TAM's affidavit that she filed. Remember now, when Justice Brigger had all this information, she had affidavits from 6 of their people. She had affidavits from Miss Raymond and Miss Tam. We can't say that Miss Tam's affidavit was the reason that the class action was granted. I would say the class action was granted because the defendants failed in their affidavits to establish the affirmative defense that the exemption, they were misclassified. These women
do we need to deal on appeal with the certification, decertification issues, were we to conclude that summary judgment was properly allowed with regard to both Raymond and Tam's?
Okay, here's the problem with that, Your Honor.
No, that's a question.
I'm sorry.
Before you get to the problem with it, could you please answer the question?
The question about summary judgment?
No, if we were hypothetically to affirm the allowance of summary judgment with regard to both of the named plaintiffs, would we even have to deal with the certification, decertification issues?
I'm not sure I can answer that question. But I will tell you this, once a class action is certified and the two class representatives are not considered appropriate for different reasons, if there's a member of that class willing to step forward and agree to be the class representative, and I had one in Mr. Brooks. Mr. Brooks was part of the class and he was ready to step forward, and the lower courts refused to allow him to do
Well, according to your brother, you stipulated that to go forward with him filing his own suit.
Yeah, I understand that's what he says, but there's a lot of things that Mr. Perlman did inappropriately. But here's the thing that troubles me the most, Your Honor, if it pleases the court. Summary judgment is happening all too often, and it really violates, in my opinion, what makes our legal system the best in the country, the best in the world, the trial by jury. And every time, and we have a sacred right to a jury trial in the Commonwealth of Massachusetts, and every time summary judgment is granted, particularly in cases involving workers, we are diminishing that sacred right for our citizens in the Commonwealth. And as a trial lawyer for 50 years, I am troubled because in the first 25 years of my legal career, I didn't have summary judgment. I tried cases, I won them, I lost them, I settled cases. But in the last 25 or 30 years, I've seen an uptake in summary judgment, and I'm concerned about it.
Okay, counsel.
Could I just get,
Yes, please.
did Mr. Brooks end up filing a separate suit?
He did. He
Okay,
did.
counsel, the most dramatic moment in a fairly dramatic transcript is where your client admitted that she signed her interrogatory answers without having read them because, quote unquote, I trust my attorney. I wanted to give you an opportunity to respond to that.
That was a sad piece of news for me because she trusted a lawyer that was ultimately suspended from the practice of law. He did something that was wrong, something that was bad, something that I feel awful about. But the fact of the matter was she signed the depositions because she trusted her lawyer. Her lawyer should be the one, not Ms. Tom. Ms. Tom should not be. By the way, those answers were redrafted and the correct answers were ultimately filed by a new lawyer who came in after Ms. Tom's prior lawyer was suspended from the practice of law. So that's not Ms. Tom's fault that happened. And many people, many lay people, they do trust their lawyers. And unfortunately, that trust was misplaced.
Do my colleagues have any further questions? Hearing none, thank you very much. No, counsel, your time has expired. We're going to hear from Mr. Perlman.
Yeah, please the court. I am Max Perlman. I represent the appellees in this case. And before I jump into my argument, I just want to clarify something that Mr. Goldberg just said. He said that the interrogatory answers that Justice Milkey asked about were signed, somehow Ms. Tom was misled by her lawyer who's been suspended from the practice of law. I would simply make a note that the attorney who signed those interrogatory answers is Deborah Pearson, who is not the lawyer that Mr. Golder is referring to, and it remains as one of Ms. Tom's attorneys in this case to this day. So that's not a legitimate defense. So this is not a case, Your Honors, and notwithstanding Mr. Golder's distaste for Rule 56, this is not a case of simple inconsistencies or prior inconsistent statements between an affidavit and a deposition. And let's let the jury sort this thing out, as Mr. Golder would suggest. And one of the last things I did to prepare for this argument last night is I went back and read from cover to cover the 2016 deposition of Ms. Tam. And as I suspect that at least 3 Superior Court judges did before they rendered the orders that are before this court right now. And I would submit that the only conclusion that could be drawn from the testimony is that, as Judge Liebensberger said, Ms. Tam signed the affirmations intending to mislead the court, or at least without caring as to whether they were true. So, and here from the deposition testimony, and importantly, and I want to respond to the notion that she was terrified. The documentary evidence, so the testimony and the documentary evidence refutes, and in some instances, directly repudiates the affidavit on which Ms. Tam would like to rely in support of her opposition to summary judgment. And if the court would indulge me, one example from the transcript. I can't go through it all, but I'd just like to give one example. So Ms. Tam claimed at the beginning of this case that she said, I was not responsible for preparing or planning the budget of Mason Place. And that's important because budgeting is an exempt duty, so it's understandable why Ms. Tam would want the court to think that she was not responsible for budgeting. So at her deposition, she was shown, number one, her own resume. And that resume said that at federal management, she was responsible for the preparation of budgets. She was shown interrogatories.
Counsel, can I just interrupt you for a second?
Please, Your Honor.
To the extent you're relying on things like her resume, is read in context, isn't there a great deal of puffing that is recognized in that context where, you know, an average intern will tell you how they were critical to the life of the organization?
So I think that if it were only the resume, you might, Your Honor's point may win the day. But there are four other pieces of documentary evidence that I showed her at her deposition, all of which are confirmatory. Her interrogatories that she submitted in the discrimination case, which was also up at the appeals court a couple of years ago. Communication showing her role in the budgeting process. A budget that she drafted. I think it's over 20 pages, a budget that she drafted. A job analysis form that she filled out that described her job as including the preparation of budgets. So as a result of showing her those documents, she said that when she testified earlier that she was not responsible for preparing and planning the budget of Mason Place, that her affidavit was wrong and incorrect. She said, she testified that that was wrong and incorrect. So then when it comes time to summary judgment, she submits an affidavit that just goes back and says, I was not responsible for preparing or planning the budget at Mason Place. And what does she do to anchor that? She puts the reversal into a 32-page errata sheet that she signed on the same day as her summary judgment affidavit that says that somehow she was confused and scared and that she felt the need to agree with me and that was the clarification of her answer that she needed to provide.
Okay, so
Counsel,
okay, so first of all, you did not fully conclude her deposition. You said you were suspending it except for a couple of issues where you thought you might either be getting different documents or want to go to the court, right?
Well, conclude her deposition. I'm not sure that's a term of art. So what we did conclude the day, we did give Mr. Golder the opportunity to cross-examine, and we did have the deposition fully transcribed, which is what the rule contemplates. I will say that.
Well, I guess that's the question. What is the deposition, right? Is it a day of deposition? I mean, one thing I'm not clear about is you did resume the deposition on June 16th.
We did.
And do we have any of that in the record?
I don't believe that transcript is in the record.
And what happened at the end of that?
I think there was a limited reservation with respect to some documents that we still were hoping to get. But if you look at the rule and I think at the purpose of the rule, that a fully transcribed deposition, she received the deposition. It gave her the instruction to fill out the errata, and she had opportunities for many months to do that, and she waited until the eve of summary judgment, or when she was filing her summary judgment papers. I will also say that on June 21st, this is in the record. I stated on the record that that the deposition was closed. So to the extent that we're looking for something to close that deposition, I think that would suffice.
Yeah, I didn't actually see a record citation in your brief for that statement. So do you have that?
I'm going to ask Mr. Loftus to find that. It's in the transcript of the June 21st hearing before Judge
No, but
Ames.
we don't. Oh, in the transcript of the hearing.
The hearing before Judge Ames, that's correct.
So you're saying that is part of the record?
That is part of the record, that's correct. Yeah.
All right, I just want to be clear, we don't have a page number in the 8 volumes of the appendix.
My apologies, and we'll be sure to get that to you either by the time I'm done here or
Counsel, say we were, again, this is pure hypothetical, say we were to conclude that the clock hadn't started yet, the 30-day clock. Isn't the implication of Smallland that then she could have amended her deposition testimony as of right, that the initial version stays part of the record and you can impeach on it, etc., but she does get to amend, which one would assume would preclude you from invoking the sham affidavit rule. Why isn't that a necessary implication of Smallland?
Sure. So if Your Honor looks at the footnote 24 of Smallland, which is the portion that Judge Kaplan cited to, makes it clear that the analysis is not to affect the sham affidavit rule and is only limited to when a party is entitled to submit an errata sheet. So the SJC carves that out of the analysis and doesn't give license to use errata sheets in order to shoehorn in a sham affidavit. But there are also some other requirements that Smallland puts in place. And let's look at the context of Smallland. So in Smallland, there's a party that changes yes to no a couple times, and the judge doesn't have to. The SJC does not have to deal with the issue of errata. It's in essence at the end. But I think the SJC was concerned enough about parties changing yes to no that it decided, listen, we're going to make some pronouncements concerning errata. We're concerned about it enough to say some things about it. What the judge said, what the SJC said was there are some limitations to uses of errata. It's got to be compliant with Rule 30, which means it's got to be timely. Here we would submit it was not. It has to contain a statement of reasons that's more than conclusory. And if you'll see Judge Kaplan's order, he seems to suggest, and this determination, whether what's the part of the record for summary judgment is reviewed on abusive of discretion. So his perspective on this needs to be respected. But he said he points out that she cites to the fact that I put words in her mouth at the deposition. I think that's Judge Kaplan saying that her statement of reasons in errata were conclusory. They have to be advanced in good faith. And if you see Judge Kaplan's decision, he refers to Judge Liebensberger's decision that says that the errata and that the testimony at the deposition was false and misleading.
How can that be resolved on the paper? The question of good faith.
I would submit, Your Honor, that simply looking at this transcript and the documentation, one can conclude that the errata sheet was not put forward in good faith.
Counsel, how do you address your brother's argument that part of the summary judgment record was the deposition of Raymond, and putting aside the statute of limitations issues, Raymond, at least nominally, had the same job as Tam, and Raymond is consistent in her testimony that it didn't include supervision, et cetera.
Yeah, so Ms. Raymond was, and this is something that Mr. Golder does not argue with respect to summary judgment. He makes this argument with respect to certification, but does not make this argument with respect to Ms. Raymond's jobs, Ms. Raymond's responsibilities somehow being evidence of Ms. Tom's. And in fact, they're not. Ms. Raymond was at a much smaller facility. Ms. Tom ran a $3 million, 127 unit building and was the property manager in every way, shape, and form of that building. Ms. Raymond, and I'm not sure the record reflects this, nor do I see any argument by the appellants to this effect, that Ms. Raymond's job responsibilities are somehow evidence of Ms. Tam's responsibilities. So.
You want to take a moment to respond to your brother's accusations that of the manner in which you conducted yourself at the deposition?
Thank you, Justice Blake. I appreciate that opportunity. I conducted that deposition in a fair and reasonable manner. I did not raise my voice once. I think there's an affidavit in the record from Mike Birch, my associate at the time, who was in the room with me, who testified to the manner in which I took that deposition. I take great exception to the notion that I did anything to confuse or intimidate the witness. And I think that the accusation that I did so is simply inaccurate and unfounded. I think that there's no support in that in the transcript itself. And those who know me and my reputation in this legal community, I think would be very surprised with respect to those accusations. But thank you, Justice Blake. I appreciate the opportunity to address that.
Counsel, getting back to a question I asked your brother, hypothetically, were we to conclude that summary judgment was properly granted as to both of the named plaintiffs, do we need to resolve the certification, even address the certification issue? No,
You don't. This court would not need to address that. It's impossible to have a class certification on a case that is dead.
What about the issue of the dismissal of one of your clients for lack of personal jurisdiction?
I'm sorry, Your Honor, did you say personal jurisdiction?
What about that issue? Do we have to reach that issue?
Sure. I would just say that the record does not reflect any ground to determine that the Superior Court had personal jurisdiction over.
No, but that's not my question. My question is, were we to affirm the allowance of summary judgment as the named plaintiff, do we have to reach the issue of whether or not the court had personal jurisdiction over one of your clients?
You're stretching my brain a little bit. I would say no. I don't think that would have to be revisited. The claims are inadequate as a matter of law. I'm not sure that there'd be any import to revisiting the issue of personal jurisdiction against the defendant. There's nothing unique about Mr. Shockett, who's, by the way, now deceased. There's nothing unique about him. And may I take just a moment? I want to give you the record site to the transcript. So it is volume 4 of the appendix at page 28 is where I say, the court says, if the deposition concluded, and I say the deposition is concluded except for, and Mr. Goldward had the opportunity to ask questions. So I mean, that's I think belt and suspenders. I think that it's not required that I technically close a deposition. All that matters is that it's fully transcribed, which it was here. But to the extent that the court is looking for some indicia of my having closed the deposition, I think the record contains that.
And I guess I just want to double check with you, because if we were to say that, if we were to say, okay, every day of a deposition is a separate and independent day, and you got 30 days to do an errata sheet, that's going to apply not just to this case, but that would apply to the entire civil bar in every single civil case. And do you all think that the entire civil bar wants to live with that? Because that's what is going to happen if that's what we do.
I think that's what is understood currently. I think that to hold otherwise would create situations where stenographers on multi-day depositions would have to confer together and put together one transcript, which does not happen. Oftentimes, you have 3 days of a deposition or 2 days of a deposition, and they are recorded by separate stenographers. And it's not one stenographer's job to fully transcribe another stenographer's deposition. So the way in practice it works is you receive a transcript and you submit the errata within 30 days.
Counsel, isn't another response to Judge Henry's question that the parties could always agree to extend the deadline?
Otherwise.
And we often do. Here there was no such agreement, nor frankly is there any prejudice to Ms. Tam for anything that happened here. She had the ability. Discovery, by the way, closed right after the parties were before Judge Ames in June. So to the extent that even if I hadn't closed the deposition, Judge Golder should have considered it closed once I no longer had the right to take any additional discovery.
Okay, counsel, one last question
Yes.
for me.
Yes, Your Honor.
What's the statute of limitations on the retaliation claim of Raymond's?
The statute of limitations of the retaliation claim? That's a good question. That's a 3-year statute.
So what was that claim, putting aside the merits, was that claim then timely with regard to Raymond?
Our argument on that is not statute of limitations. Our argument is that there was no protected activity pursuant, and the record's clear that she did nothing but ask for a raise in essence, and that's not protected activity under the law. The argument with respect to the statute is on her overtime claims.
So we would have to reach that issue in any event.
That is correct, Your Honor.
Okay. Do my colleagues have any further questions? Hearing none, thank you both very much. The case is submitted.
Thank you very much, Your Honor.
The case is now being recorded.
Thank you very much. We are now back on the record for the final case of the morning. The case is 2020 P161 Metropolitan Property and Casualty Insurance Company versus Emerson Hospital. And we'll begin, I believe, with Attorney Gaimari. And my apologies if I mispronounced the name.
No, very well done. Yes, Frank Gaimari for Emerson Hospital. I tried to outline my argument as succinctly as I can in my brief. But I think for argument purpose, the easiest place to start is the no-fault law itself. It was enacted in 1970. And in 1970, when PIP, no-fault, came into play, there was no such thing as a preferred provider organization. Managed care and its offshoots, the HMO and the PPO, didn't exist until 1973 when Congress passed the HMO Act at 42 USC section 300E. Up till that time, in Massachusetts and all around the country, we had fee-for-service medical care. The first time there was ever a preferred provider organization was in 1980 in Denver, Colorado. And the first time the words preferred provider organization or PPO appear in any case or decision anywhere in the country was in the First Circuit in Cartel versus Blue Shield in 1984. So the arrangement.
Counsel, I understand you are making a statutory argument, and I understand you also have a contract argument based on the 4 people who only were treated in the emergency room. But what I don't understand about your statutory argument is, because you've cited several statutes, including parts of Chapter 90, 175, 176D, and 176I. So are these 4 separate and independent statutory arguments, or are some of them interdependent?
Well, they are interdependent. I mean, if we look at the PIP statute in and of itself, my brother has to concur that there's nothing in the PIP statutes, 34A and 34M, even remotely suggesting that arrangements of this sort were contemplated by the legislature or are permitted by the statute. In the no-fault scheme, pretty much the whole common law scheme of torts was upended, and the legislature commandeered the automobile insurance scheme and the previous tort scheme that we had. And they provided a remedy for, they replaced damages and tort with contract benefits under the PIP statutes. And there was no common law analog, and at least as a matter of law, when the legislature has taken over a subject, the statutes that they enact fully govern the party's rights.
So
And
if,
there's nothing in the statutes that say anything about that.
so counsel, if Metropolitan pays only according to the contracts here, what impact, if any, does that have on the insured?
Well, the most obvious one is, and I raised this in the brief, is that the insured is paying for PIP benefits. He's paying a premium set by the Commissioner of Insurance, anticipating that the insurer is going to pay all reasonable expenses for necessary medical services. In this case, the insurer is paying less. Now,
Right, but the insurer's response to that, and so I want to hear your response, is that in fact the insured is potentially getting more medical care because of that, because they get $20,000, for example, and because of the 30% discount, they might actually get more benefit.
well, the word "might" is the key. The only time this is ever going to come into play is when the insured exhausts PIP benefits. In other words, has over $8,000 in PIP expenses, which, yeah, it can happen, but it didn't happen in these cases, and it doesn't happen in the majority of cases. So the only one here who benefits by it is the insurance company.
Yes, but I guess the question is the insured harmed by it?
Well, yes, he's paying more for his insurance than he otherwise would have to. If this had been run through the regulatory process, if Metropolitan had gone to the Commissioner of Insurance in the yearly regulatory and rate setting hearings and said, look, this is what we're doing, and this is the loss, this is what we've saved in paying PIP benefits, well, there'd be a corresponding reduction in premiums across the board.
Counsel, just now and in your briefs, you make a lot of arguments, or both sides do, in terms of the role, if any, of the Commissioner of Insurance. Do we know the position of the Commissioner of Insurance on these issues?
No.
And more generally, and how these pieces fit together?
No, this has not been brought to the Commissioner
Doesn't
that I know of.
Go ahead, Judge Milkey.
Now, should we solicit the Commissioner of Insurance's opinion on these issues? Or put it this way, why wouldn't we want to?
Well, I think well, you might want to, but I think the process is to have the Commissioner make a ruling either in this case or some other case, and the parties to rely on that ruling as precedent, or at least as something to argue in favor or against, in favor of their case or against the other party's case. I don't think if Your Honor is talking about an advisory opinion.
No, I'm talking about amicus brief. We could.
Well, they didn't do it.
No, I understand that we theoretically could solicit the Attorney General or invite the Attorney General to file a brief on, either or both the Commissioner's behalf or for that matter, the Attorney General's behalf, given the role that she has by statute in being involved in just about every aspect of the healthcare system.
Right. Well, that would be, the court's, that would be certainly the court's prerogative.
But you would agree that this outcome could have far-ranging implications for hospitals and insurance companies going forward. And I guess, here we're talking about 5 actions. Are you aware of other actions that are pending in various places, whether it be the trial court or the appeals court, concerning this very issue?
Well, my brother, it's actually 3 actions. I was incorrect in my brief. There were 3 patients I consolidated, but that's neither here nor there. My brother was correct. It's three actions. Yes, there's cases all over the place dealing with this, filed by my office, filed by other lawyers' offices.
So is this not unusual? In other words, is Coventry the party that keeps popping up in these cases, or is this happening system-wide?
This happens system-wide. Coventry is one of them. There's these quote PPO organizations, or I don't even know what you would call them. You see them once and then you never see them again. And there's others that you see with some regularity.
Do you know if any other cases have been argued and are currently under advisement, or to your knowledge, is this the first case to address this issue?
At the upper level. I mean,
Right.
There's been district court cases and district court appellate.
But nothing at the appeals court or the
Not that I
SJC
know
that
of,
you're,
no.
okay.
And if it means anything, I know pretty much everybody that does this in this area of law, and I've run my brief by, some of, at least one of the other participants, and he certainly would have told me if there was.
So, counsel, I want to just go right to the statute, because if you can, put aside the stipulation about the reasonableness of the expenses for which you were seeking reimbursement here, and just look at the language of the statute.
Mm-hmm.
Why isn't the obvious way to harmonize these different statutory schemes would be to say that what is reasonable needs to be seen in context? And in this case, where the hospital agreed to a reduced rate, it is reasonable to give them that reduced rate, that's the reasonable amount. Or put differently, it would be unreasonable to give them the spot market rate on this where they've agreed otherwise.
Well, first of all, the statute, Chapter 90, Section 34A, mandates that insurers pay all reasonable expenses for necessary medical services, meaning that if a bill is reasonable, it must be paid in full. And my brother brings up in his brief, well, there's a range of reasonableness, of course, but
No, I understand that's the approach they took, but stipulations and even arguments made to us aren't necessarily binding. I'm not talking about the who wins issue. Waiver applies in that context. I'm talking about what the hell does this statutory scheme mean? And I've offered a way of harmonizing the two, and I would like to know your response to that on the merits.
Right. Okay. Well, divorcing ourselves from this particular agreement and all, medical providers in today's environment with managed care, they enter into contracts with health insurers such as Blue Shield, United Health, whatever, and accept dramatically lower rates than they otherwise would on the spot market, as Your Honor called it. But in return, they have a whole universe of clients. All of the patients, all of the patients insured by Blue Shield can go see this doctor. So he or she makes up in volume what he otherwise would have got in charging higher prices for his services. If you look at this particular PPO, and for lack of another term to call it, they offer no patient subscribers. In other words, there are no patients signed up with Coventry who are steered toward Emerson Hospital and others in the scheme. So that's the vein difference. I mean, Emerson Hospital gets nothing for having done this.
Right, but Emerson, I mean, it's a sophisticated organization, I take it.
Well, I'd love to say yes, but but whatever.
Okay, so, but Emerson could say in its contract with Coventry, this does not apply to emergency room services, where
It did.
people typically are not shopping around, right?
It did, in this case.
And where is that in the record?
Appendix 192, section 4.2. It says that in that agreement with Coventry that the payor, which in this case would be Met, shall pay all reasonable costs associated with emergency services. And that's pretty much identical to what the PIP statute and the auto policy say. So they did.
Oh, I'm sorry, you were reading from the contract?
Yes, the contract between Emerson and Coventry at, as I said, appendix page 192, section 4.2 provides that emergency services shall be paid at the reasonable rate, or that the payor, meaning Metropolitan, shall pay all reasonable costs associated with the emergency services. Now, I made that argument at pages 27 and 28 of my brief. I mean, so let's put it this way. If we look at that alone, I win. I mean, there's really no other way of getting around it. But both my brother and I wanted to get at the larger issue because, as Your Honors have suggested, this is a pandemic, so to speak. I mean, it's all over the place.
I won't comment on the analogy, but do my colleagues have any further questions?
I don't.
No. Thank you very much, counsel. We'll
Yes,
hear from your brother.
Very pleased to have addressed this to you, judges.
Counsel, could you start with the question about whether we should invite an amicus brief from the Attorney General?
Well, Your Honor, the closest that the commission has come to commenting on this can be found in a case that's entitled Mitzan versus Medview Services. It's a Superior Court decision back in 1999. And in it is cited a commission decision that suggests that a PPO agreement with respect to the PIP arena would not necessarily be in conflict with the law. The problem with that opinion is it addresses the situation in which like an insurance company offers a PPO policy. Now, a PPO policy is different than what we're addressing here, so it's not exactly on point. And the big difference is that Metropolitan doesn't require its insureds to treat at a Coventry network facility. Now, if it did, and wouldn't reimburse for treatment outside of that network, then we have a different problem of the benefits that extend to the insured. Because this is what we call a non-directed agreement in that, and my brother alluded to it earlier, patients aren't steered there. So there's no incentive really to push the insureds in any direction. They're free to get treatment anywhere. This agreement.
But isn't that the problem? Because it creates some arguable unfairness where they've agreed to the reduced rate as a quid pro quo, and here there's no quo.
Well, the issues of consideration is what I think the court is getting at, and whether or not Emerson gets anything out of this. And to answer that question, first of all, the stipulations are that that's not an issue, and these are binding and valid contracts. For the economic sense of entering such a contract is really beyond the record here. However, if you
no, but isn't the issue what the contract means? And
certainly,
your brother read this from the appendix that at least one interpretation of is for emergency room services are different.
Well, we disagree, Your Honor, with that interpretation. You have to look at this contract as a whole, because it doesn't apply just to auto insurers, right? It applies to health benefit plan HMOs. It applies to workers' compensation insurers and various other payors who are in the network. And the reason why the emergency room record or emergency room treatment provision is in there, because there are instances in which someone would treat through their HMO at an emergency room versus, let's say, their primary care physician's office. And that would be a basis for an HMO to say, you should have gone to your doctor and not the emergency room. And so that provision is really a catch-all to prevent the payer from using that type of argument from denying payment. And so in addition to those types of benefits, this case really started because of the other benefits to Emerson Hospital, which include an internal appeals process, the provision of binding arbitration to resolve these matters rather than resorting to litigation. And so there are multiple benefits that can be seen as to why Emerson would enter this agreement. Certainly, Metropolitan may at some point benefit from a reduced payment over the face value, but whether or not that's actually an economic value remains to be seen. As Attorney Gamari pointed out, hospitals and medical providers often enter contracts with health insurers to accept less than their face amount. Everything from Blue Cross Blue Shield to Medicare, Medicaid, they often accept less than the face value. This contract simply tries to simplify the reasonableness requirement of the statute, which is not defined anywhere. And as pointed out, those amount, it's not important to focus on what the bill is, it's the amount of payment. And so how do we determine what a reasonable payment for services is? We've had this litigation.
Counsel, didn't you stipulate that the amount they were seeking was reasonable? And why doesn't that, if so, why doesn't that sink your case in and of itself?
Well, because the stipulation is not, that's the only reasonable amount that could possibly ever be paid. We stipulated that was a reasonable bill. The question is, did we pay a reasonable amount? Those are two distinct questions, and they're not mutually exclusive. Because if the bill can be seen as reasonable and we pay a penny less, is that reasonable? If we pay 5 cents less, is that reasonable? And so that's the difference, is what the payment is important. What if Emerson Hospital pay, overcharged? So these are the issues that have been addressed through prior litigation over the years, is how do you determine that? One way is a medical review. A doctor reviews the treatment and says, well, is this reasonably necessary? There's been fee reviews where databases are collected and used to reduce those bills. And if you look at the Commonwealth Automobile Reinsurers Standards that were promulgated pursuant to the statute 175, it suggested that not only are the fee reviews suggested and required, independent medical examinations and so forth, but also it encourages the use of preferred provider agreements and managed care. And that's exactly what Metropolitan did. This is a benefit to the customers who, as you alluded to previously, in that they get more service for their premium. They don't get less. And that's really when only time
Just to clarify, are there any circumstances under which someone in the hospital's position could try to go after the driver because the full expenses were not reimbursed by the PIP insurer?
In the at-fault case, there are instances of subrogation issues and certain of the lien issues that do come up, but not in the PIP context. So if they're looking for no fault benefits, they are limited to recovery to the PIP insurer as well as the patient who received the services.
So they can go after the patient for the delta.
Yes, so they're the patient.
But based on fault, not based on contract.
I thought you just said no fault.
I did say no fault. So there are two different instances. They could go out after an at-fault party and serve a lien on the proceeds of a bodily injury type payment. In the PIP context, on the first party, they always have a claim against the patient who received the services. In addition to the PIP, the issues that you start to run into when you go after the patient is if there's health insurance involved and they cannot balance bill. If the health insurance paid a portion of it, they can't go after PIP for the balance in those instances. And that's the Shaw case, which is really similar to what we have here, is that there's been an agreement by the hospital to accept the payment. And now they're trying to get the balance of that payment by ignoring that contract and going after PIP for the balance. Despite the agreement that they admit they had made, they admit that auto insurers were payers. They admit that they were paid correctly. And that goes back to the emergency rooms issue as well.
So counsel, I'm trying to understand in the PIP context, once Metropolitan pays the contract rate, can Emerson go after the patient for the 30% Metropolitan did not pay?
No, because at that point, they've agreed to the rate. And so there's no balance. That's why they're not an unpaid party, because once they've agreed to accept a rate and it's been paid, then they have no rights to go after anybody. So
they just write that off.
I assume so.
Presumably.
I assume that's what happens when they get less than 100% from any insurer. They don't go after the patients.
Is this a wide-ranging problem in the industry right now?
It's not as common as it seems. It seems that, there was a fair amount of litigation that led up to this case. In my office has not seen a huge influx in these cases as of late, but I do know that there are multiple networks with other insurers that are out there, as evidenced by the numerous district court cases I cite in my brief.
And you're not aware of any cases that are pending in our court or the SJC?
Not that I'm aware, and I did double check as recently as yesterday to see if I could find anything else that had bubbled up, but there's not. And that's why in my brief, there's cited some other jurisdictions that have addressed the issue. But again, those states actually allow for a PPO policy, which this is not. And again, that's why there's no reduction in coverage in this case, because Metropolitan still is required to pay $8,000 in PIP. It just means to determine the fee for service.
But don't these issues come up all the time in the non-PIP context, where patient goes to a doctor or a dentist, gets a preliminary bill, it gets submitted to the insurer. Insurer says, we're not paying that. This is what we agreed to reimburse.
Just as a point of order, the clock reset to 15 minutes and then it just reset to 7.5 minutes. You had about 4 minutes, but I have a number of questions. So if you recall Justice Milkey's question, answer that and then we'll continue.
Yes, it does, Your Honor. And and the strength of those preferred provider agreements is similar here, that they're foregone the 100% face value of the bill in order to have a relationship for prompt payment under these agreements.
But the difference here is when you add a layer of PIP no fault, where the bills typically are in the emergency room context, it adds some complications.
It does indeed, Your Honor. And part of the benefit of this type of agreement is to eliminate that litigation, which is really over what's the reasonable amount of the bill. And so, when you have an agreement agreed by, the parties who had opportunity to negotiate a fee agreement and provide for these other, ways of resolving it, such as the ADR provision, that makes a lot of sense to take that reasonable issue out of the equation.
Except perhaps when the attorney stipulates that it's reasonable.
Agreed. But again, because the bill is reasonable doesn't mean that the payment was unreasonable, and which is the requirement of the statute.
So the motion judge noted that the Metropolitan Coventry contract went into effect before the Emerson Coventry contract went into effect. Does that timing matter?
Not necessarily. It certainly, makes the, because of the language itself, I don't feel like that's particularly important. What would be important if the types of insurers changed. In other words, you went from agreeing to have HMOs only involved, and all of a sudden we're trying to apply it to an auto insurance policy. That would be a lot different. And that's sort of the problem with the Mitzan case that I referred to earlier, as they were attempting to get the case applied to auto insurers when really it talked about employee benefit programs. And so some of the contracts that have been out there that precede this one had a lot of problems with the contract language, admittedly. And
now, if I heard you correctly, that was a 1989 case?
I believe it's 99.
99, but either way, I assume you would agree a lot has happened to the healthcare industry in the last 2 decades.
Oh, certainly, Your Honor. And again, I assume the case is not on all fours with this case, and I suppose that's probably why neither myself nor my brother cited it. However, you brought up the commission's comment on this type of area, and that's really the only place that I was able to find the commissioner touching on this issue.
So Emerson argues that had the legislature intended that PPO arrangements be applicable to PIP claims, that it's had every opportunity to do so in the last 30 or so years. What do you say to that?
Well, I say it also had the opportunity to prohibit it. And where a statute doesn't, preempt the issue by saying, explicitly, you cannot make a contract that violates this statute, then you have to look at what the purpose of the statute was. And importantly here, these contracts really do further the purpose, which is prompt resolution of medical claims arising out of motor vehicle accidents, and controlling costs. These contract arrangements do both, and are in no way in conflict with any provisions of the statutes that apply.
I'm on this chapter 176, and I don't remember now if it's L or D, but this issue about, I think it's L or I, what is it's the definition of organization. Is Metropolitan an organization under that definition?
No, Your Honor. In order to understand whether or not it is or not, it's a little bit convoluted in reading the statute, but the definitions clearly state that it's an organization that is offering covered services which are provided by a health benefit plan. All the regulations that follow and the definitions really contemplate that is intended to regulate health benefit plans and providers of health insurance.
In dealing with the contract argument, which I think is paragraph 4.2, are emergency services inpatient, outpatient, or something else?
Well, I believe it certainly would depend, but I believe it's an outpatient service. But again, that's captured in the appendix, which provides for the rate setting that includes any bills that were sent under the tax identification number of the provider shall be paid according to that provision of, I believe it's Appendix A/B.
So obviously, I understand each one of you says that you should win. I guess what I'm trying to understand is, what do you think is the simplest path for your client to win, weaving through these various statutes?
Well, Your Honor, simply to affirm the decision of the Superior Court. This was on a case stated to simplify the issues as much as possible, which the court was simply asked, was Metropolitan entitled to rely on these contracts to pay the amount of Emerson Hospital's bill? And that clearly eliminates Emerson's status as an unpaid party on the statute, which would result in Metropolitan prevailing.
So I'm still trying to understand the interrelationship between these 4 different chapters, though. So that's what I'm trying to understand is, do you have to win on all 4 of those chapters, or do you win if we agree with your argument on 1 of them, 2 of them?
I suppose, are you asking about the individual claims of the patients?
No, I'm not. I'm saying that you all have briefed lots of arguments around Chapter 90, Chapter 175, and Chapter 176, I think I and D, right? And so, like, let's say we agree with you, we agree with him about 90, but we agree with you about 175I. Do you still win? Like, it's very helpful when attorneys say to us, I win for 2 separate and independent reasons, or I win because I prove A and B, but they're interdependent. And I'm trying to just get from each one of you your view about whether these 4 chapters, whether you have to win every argument under these 4 chapters, or if you win one of them, does that mean you win the case?
Well, in all candor, Your Honor, I think if you found that Metropolitan paid the Emerson's bill in violation of any one of the statute, we would lose, because we wouldn't be entitled to pay it. So, I mean, that's the essential question, is, were we entitled to pay it? And if we were not, then you'd have to find that there was a violation of one of the statutes.
Thank you.
Judge Blake, anything else from you?
Just thinking that through. No, I think I'm good. Thank you.
Thank you. Okay. Thank you both very much. It's a very interesting and seemingly important case. So the case is now submitted.
Thank you all very much.
Before you sign off, I just want to say my thanks to the session clerk for the great job that he did.
Absolutely.
And the work more generally of the clerk's office in supporting these Zoom arguments, which I hope you would agree are about as close as we can get to the real thing.